Good morning.
Good morning, Your Honors.
Good morning.
Good morning and happy Monday. Today, we have one case scheduled for oral argument at the First District Court of Appeals, and that is case number In Re AB, a minor child, case number C210010. If attorneys can please identify themselves and their readiness to proceed.
Yes, Your Honor. We have Andrew Hockala Finch here with the Hamilton County Public Defender's Office for the defendant appellant AB. We are ready to proceed.
Thank you.
Good morning, Your Honors. Keith Sauter for the state. I'm ready to proceed.
Thank you. Attorney Hockala Finch, would you like to reserve time?
Yes, Your Honor. I'd like to reserve 3 minutes.
All right, whenever you're ready, you can proceed.
Thank you, Your Honor. May it please the court, my name is Andrew Hockala Finch, and I represent the defendant appellant AB. The juvenile court abused its discretion when it awarded restitution to a victim that did not suffer any actual economic harm. No evidence or testimony was put forth on the record that Jerry suffered any actual economic loss. In fact, at the restitution hearing, Jerry's mother testified that he had not made any payments towards these outstanding medical bills, and nor did he intend to make any payments towards them in the future.
So is it your position that a duty to pay is not sufficient?
Your Honor, our position here is that he had not made any payments towards these medical bills and records. Additionally, there had been substantial write-offs and reductions and the possibility of those in the future as well as the fact that he had not suffered any damage to his credit score. Neither had there been any default payment status.
Okay, and in the record, what was the evidence that there may be future reductions?
Your Honor, these were the initial medical bills that had been issued, and those first bills contained $9,675 and some change in write-offs and reductions, and those were the only bills that were presented. There was no hard evidence in the record that there's a possibility of that, but medical bills are immutable, and there's nothing in the record that said that there would not allow future write-offs and reductions as well.
All right, thank you.
I follow up on Judge Zayas's question because I want to make sure I understand your position. If somebody owes a debt, even if the creditor writes it off ultimately as bad debt, is it your position that that's not an economic loss suffered by the borrower or the person who owes the debt? I mean, just because it's an accounting principle, at some point in time, they have to write it off as bad debt. That doesn't mean it isn't owed, is it? Does it?
Your Honor, our position is that it does not substantiate actual economic loss for the purposes of the restitution statute. Similar to the State v. Dent case out of the 11th District, where that court held that damage to one's credit score is not enough to substantiate actual economic harm. And here, we don't even have any evidence that Mr. Bryant's credit score was negatively affected. So it is our position that because there was no showing of any actual economic loss and there was no default payment status, there was no showing of damage to his credit score, that for the purposes of this restitution statute, that no actual economic harm had been substantiated. And as we were talking about earlier, there was no testimony or evidence put forth as to the status of the bills, whether this was in default, whether they were in repayment status, and if they were, what the terms of those installment plans were. Now, also, the evidence put forth at the restitution hearing was not competent or credible, as we had discussed before. These medical bills presented were 7 months old at the time of the restitution hearing and contained significant write-offs and reductions as well. There was no evidence put forth that write-offs or reductions could not happen again in the future. And the First District has dealt with this issue in State v. Purnell, in which it stated that unsubstantiated medical records and hospital bills is not enough to substantiate a victim's out-of-pocket losses. This is important because double recovery is at issue in this case due to that possibility. This is analogous to a situation in which a victim were to have a piece of property damaged and were to receive that property fully repaired and restored, yet also receive a restitution order for the full cost of that piece of property. The only party to suffer an economic loss in this instant action were the third-party medical vendors. However, restitution may not be ordered to compensate the losses of third parties. And during the pendency of this case, the court issued a decision in State v. Wilcox. And in Wilcox, a defendant had stolen a victim's credit card. And that defendant had racked up several $1,000s in credit card bills. The issuing bank for that credit card covered the losses and did not affect the defendant's credit score. I mean, the victim's credit score.
Isn't that a difference? Because in that case, it was in the record that it was that the victim of the crime, in fact, was not going to have any economic loss because it had been covered by the banking institution or by the credit card.
Yes, Your Honor, there was that additional bit of evidence put into the record at that hearing as well. The medical vendors were not at this restitution hearing in the instant action.
And I want to go back to the Purnell case, to your point with regard to Purnell. In this case, you had the mother of the victim testify.
Correct.
And so there isn't an adverse determination on credibility from the trial court with regard to mom. So how is it that mom's testimony coupled with the bill is not sufficient?
Your Honor, the issue in this case is that these bills had been issued 7 months prior. They contained significant write-offs and reductions with the possibility of future ones. She had also testified that Mr. Bryant had not made any payments towards that medical bills, that Mr. Bryant does not work, and there was no evidence or testimony put forth that he had been affected negatively in an economic sense by any of these hospital records or bills. That no evidence about his credit score and specific testimony that he did not intend to pay these medical bills at all.
Wasn't that because he didn't have the ability?
Yes, Your Honor. And Your Honor's due process requires that restitution bears a reasonable relationship to the economic loss at hand. And this is the heart of our argument here. Mr. Bryant did not suffer any economic loss. However, the restitution ordered by this court does not bear a reasonable relationship to the economic loss at hand. And therefore, because of that, Defendant AB respectfully requests that this court reverse the juvenile court's issuance of a restitution order. Thank you.
Thank you. I do have one more question. As I recall, the trial court made some sort of statement to the effect that if things were to change with regard to the billing, that the parties or the victim can come back to the court and then the restitution order can be adjusted. Are you familiar with what I'm referring to?
Yes, Your Honor.
So my question is this: how is it that does not cure? Does that cure any issues that you have?
It does not cure the issue, Your Honor, because it would be completely dependent upon Jerry and the victim, and in this case, the victim's mother, who is handling his records, to bring that information forward to the court. So if there were another $9,000 write-off and reductions, but that was not reported to the court, then that would be a result of double recovery. There's really no way for AB to check in on that.
All right, thank you so much.
Thank you, Your Honors.
I'll reserve the rest of your time.
Thank you.
Attorney Sauter?
Good morning, Your Honors. May it please the court. Judge Zayas, your final question there kind of stole my thunder. I was going to lead off with the comment that the trial court did place an ongoing duty on the on the victim here to supplement if any bills, if there were any further write-offs or if there were any indication that the
But to Mr. Hakala Finch's point, isn't that dependent on the victim? And
it is, Your Honor, but
secondly, what with regard to AB, how would he know what the status of the building is and how would he have access to such?
Yeah, I understand the enforcement problems, Your Honor, but I think that, this might be a bit naive on my part, but we have to assume some good faith here on the part of the victim. This wasn't some kind of cash grab where they were, attempting to seek a windfall here. I think this was a legitimate pursuit of damages, and I don't think there's any indication in the record that there would be any bad faith on the part of the victim or the victim's mother to game the system to get a double recovery. In terms of whether or not there was an economic loss in this case, I think the Purnell case, as well as State versus CSIC from the 12th District, indicate that economic loss means any amount that's paid or owed. And I think that there's an economic loss in being indebted to the medical providers in this case. And the case is cited by the appellant Wilcox and mainly Wilcox is there, and in Wilcox, which was decided since while this case was being briefed. The guarantor had been released from any further obligation, or been released from any further obligation on the debt, and it indicates that the creditor could not go after the guarantee in that case. In the other cases, there was evidence in the record that the creditors would not pursue payment against the victims in that case. So I think that we have a difference in that case. Here,
and I think that part of the point is not so much that it's not owed. I think what it comes down to is whether the evidence in the record is sufficient, whether the testimony of mom coupled with the record is sufficient. In comparison to Purnell, the court said the record in this case contains no credible evidence of economic loss beyond the unauthenticated hospital and medical bills.
Right. I think part of the problem in Purnell was that those unauthenticated bills were submitted after the trial court essentially lost jurisdiction to even decide the case. And there was no indication in Purnell that that there was testimony to support the medical bills that had been submitted to the court. In this case, we do have the authentication of the bills on the part of the victim's mother, who was intimately aware with the medical services that had been provided to the defendant or to the victim, and there's no indication that there was any attempt to exaggerate the extent of the loss. And I think that in this case, the appellant essentially concedes that the state made at least a prima facie showing that the medical bills were reasonable, and absent any evidence to rebut that, it's the state's position that the trial court did not abuse its discretion. Unless the panel has any further questions, I'll rest on my brief.
Thank you. Attorney Hakala Finch, so you have 6 minutes.
Just a brief rebuttal, Your Honor.
Okay.
The state mentions in their argument State v. CSIC. CSIC was an issue in which the defendant and the attorney did not object to the restitution at hand, and so the court was reviewing that under a standard of plain error. Again, our argument is that the restitution order of $19,485.45 does not bear a reasonable relationship to the economic loss at hand, and there was no showing of an economic loss. As to the authentication,
Can I interrupt you and ask you about the authentication?
Yes.
I know the rules of evidence don't apply to the restitution hearing, but assuming that they did, wasn't it authenticated? The mother testified that they were received, that they were the bills from the hospital. Isn't that enough to show that they are what they purport to be? Now, there may be other issues, but as to authentication, weren't they authenticated?
Your Honor, it's our understanding that authentication requires a signature from the records custodian of the the records custodian of those medical records in order to be considered authenticated. The cases cited in the state's brief are dealing with a revised code statute in regards to presenting information in wrongful death statutes. It's our position.
Isn't the requirement that they be certified, that's not just, that's when there's nobody to testify as to their authenticity, right? Isn't that when you're trying to get them in as self-authenticating?
That's in lieu of bringing the records custodian into court and testifying themselves, Your Honor. But that's the requirement for authentication, is the affidavit that these record custodians place on these records.
Do the rules of evidence apply as they would at trial, the restitution hearing?
No, Your Honor.
So what do we do with that? And how does that coexist with your argument of authentication?
Your Honor, what this coexists with is that the state should have put on more evidence at this restitution hearing in order to actually give the court and the defendant a full picture of what the current status of these medical bills were. There was nothing about if we don't know if there was an installment or repayment process, we don't know the status of it. And these bills were 7 months old at the time of the hearing. And in lieu of having records custodians or representatives from these third-party medical vendors come to the restitution hearing, they should have provided authenticated documentation as to the current status at this restitution hearing, Your Honor.
Thank you.
Thank you, Your Honors. And again, the restitution order issued by the juvenile court does not bear a reasonable relationship to the loss at hand, and therefore AB is requesting that this court reverse the juvenile court's restitution order. Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and have a wonderful week.
Thank you, Your Honor. You too.
And
Thank you, Your Honor.
our arguments. Thank you.